Welcome to another episode of In Chambers with Mohammed Muigai. My name is Caroline Kaunda, an associate in the Dispute Resolution Practice Group. I am joined today by Mr. Georgiadis Khaseke. We will be discussing the evolution of environmental law protection in Kenya, and we'll be focusing on the pre-2010 constitutional dispensation and the post-2010 constitutional dispensation in discussing how these protections have evolved, the manner in which the courts have applied different doctrines in making their awards. George, could you kindly introduce yourself?
Thank you very much, Kaunda. My name is Khaseke Georgiadis. I'm a partner here in the Dispute Resolution Department, and thank you very much for having me for this exciting session.
You're very welcome. So just to begin, we have a constitution today that provides for a lot of rights and freedoms, including the right to a clean and healthy environment. And we have seen Kenyans increasingly moving to court to enforce these rights in light of increasing pollution. Could you please give us an idea of how the landscape looked like prior to the promulgation of the 2010 Constitution?
Thank you, Kaunda. I think when we talk about the 2010 Constitution and the fact that it is been transformational, one of the areas that actually is highly exhibited is in the area of protection of the environment and the guarantee to a healthy environment. Now, prior to 2010, of course, with the previous old constitution, we didn't have this right put in the constitution or constitutionalized as it were. But 2010 constitution, we are seeing that environmental issues, protection of environment, and the right to health to health is now elevated, and it has a constitutional imperative. And because of that, then everything and anything that we do, both at the individual level and even at collective or community level, has now that constitutional sanction. So we now have the right to a clean environment and the right to health being given that constitutional elevation. And because of that, then it binds.
Okay, so prior to this constitutional embedding in the Constitution, how did protections look like? If you felt that your environment has been polluted, on what basis would you move the courts?
So initially, the approach was to a large extent a common law approach. And basically, when we're talking about a common law approach, this was based on the doctrines or principles that had been developed over time by judicial organs, the courts in England, and even some of those principles then found their way in the Kenyan judicial system. So maybe to just put context, when we're talking about common law and how this protection would then come in, or somebody who is aggrieved by any measures that have been taken will then have to approach court in through a civil process, and the court will then apply the common law principle. And to a large extent, it used to be the fault-based system.
Mm-hmm. This is under negligence, the tort of negligence.
Negligence. So you would start from negligence, and I think from a civil law perspective, there would be you had to demonstrate that there was a civil wrong. So meaning that somebody did something wrongly, thereby affecting or causing certain injuries. So that was from negligence. Then, of course, we now had certain principles that were developed by the court, such as the rule in Rylands and Fletcher, where we were now seeing a slight departure and this departure was to a large extent informed by the Industrial Revolution, especially in the West, the coming in of companies or industries and some of their activities when they are carrying out their operations. So we then had this concept of strict liability, where unlike in a normal or a conventional tortious claim, where you had to demonstrate that there was a wrongdoer, somebody did something wrong. Here, the courts were not looking at blaming somebody; they were looking at whether or not injury has been caused, and that is the concept of strict liability.
So could you kindly just expound a little bit on the elements you would find that you needed to prove to the court under this rule developed in Rylands versus Fletcher?
So under that rule, basically it required somebody to have brought something to his premises, be it his land, his building, and that thing that they brought, in most cases it would be something hazardous, and if that thing then escapes, basically means that it leaves the premises and it causes injury maybe to a neighbor or to somebody, then that person would be held liable, because it was deemed that he was in charge of how that substance is to be kept or to be stored. And if it escapes, so that is where now the issue of strict liability comes in. It was not upon him now to say that perhaps he was not negligent in releasing the material or the substance as it was. So long as it is escaped and it caused injury, then the person would be.
So in essence, the courts were telling you, you can deal with your land in whatever manner you want to deal with it. Yes. But if you collect on it something that is not in the natural use of the land and it escapes, whether you had the intention for it to escape or not, you will still be held liable.
You will still be liable, yeah.
And so our courts adopted that rule in holding people liable under environmental protection cases. So then how has this evolved in the current landscape under the 2010 Constitution?
Yes. So under the 2010 Constitution, in fact, there are two material developments. If you look at the Constitution in terms of environmental protection, one is that, as we have said, if you look at Article 42, whereas it guarantees that right, then when you go to Article 70 of the Constitution, it provides for how enforcement mechanisms can be done. Now, when you're looking at strict liability, for instance, is somebody who would be coming and saying they have suffered, in there's the aspect of locus. It is in their personal, or even if it is at a group level, they are saying they have suffered. But in the Constitution, you find that any other person can actually take up a claim where on behalf of somebody, or where they are saying that there has been injury to the environment. And one of the interesting things that you will notice, especially if you look at Article 70, paragraph 2b, there is actually an express provision that, once the court determines there's been injury to the environment or pollution to that matter, it can even order a public officer or official or entity to take certain measures to mitigate that injury. And then when you come to paragraph 3 of Article 70, it also gives a very interesting aspect. It says that the person who seeks to enforce that right to a healthy and clean environment can actually bring this application without the necessity of proving any loss or damage that had been caused to somebody else.
Just to backtrack, you're saying that one can move to a court of law and not be required to demonstrate the harm.
Yes.
And so ideally it will just
be
the
loss, actually, or the injury. Yeah.
The loss or the injury.
Yeah.
So then you just have to show the threat to the environment.
You have to show the threat or the injury itself. So there is that aspect of the loss. So you see, when you are looking at a civil wrong, there are two elements to it for you to be successful. One, you must be able to demonstrate that there's a wrong that has been done. Okay. And then two, that when that wrong was done, then you suffered some loss or damage. Now, what we are seeing, one of the innovations of the Constitution insofar as protection of the environment is concerned, and the fact that a third party, somebody who has not directly been affected by whatever measures were taken, which of course affected the environment, is they are entitled to file an application to enforce, but they are not required to demonstrate that there's been a specific loss or damage that has been caused.
Okay, interesting. So how then would the court assess the award to be made, say either to remediate the environment or to compensate the people who've been harmed by whatever, or where there's just the threat? What are the remedies then that the court will give?
So there are several remedies that the court will, and maybe just to take you a little bit back, because it is now a constitutional right and imperative. Once there has been demonstration of breach of this right, then the provisions of Article 23 kick in, and like in a conventional civil claim, the Constitution then allows the court, once it has found or established that there's been a breach of a constitutional right, to issue or to issue various forms of remedies. Of course, there is the conventional one, which is compensation, but it can make declarations. It can, in fact, if you look at Article 70 that I had alluded to, then you'll find that Article 69 and 70, it can also issue a structural interdict, and that basically is a sort of a special remedy where the court can issue a directive and even supervise how that remedy how corrective measures are going to be put in place in order to ensure that the wrongful measures or the wrongful actions that actually threatened the pollution or damage to the environment are actually carried out.
Okay.
Yes.
So we've increasingly seen, I don't want to call it criticism. Let's call it critique of the decisions that have been coming from the courts, where the courts are now seen to be activist in the kind of awards that they're making when parties move to court to enforce these rights. And I would like you to just contextualize that for us in view of the doctrine that you mentioned. And is the court still applying that strict liability doctrine when it's making these awards, or has it modified or relied on any other doctrine in enhancing these compensation awards?
Yeah, so as we had indicated in the initial pre-2010, it was the common law doctrine. And then I think when it comes to protection of the environment, where especially there's been an allegation of breach of that right, then the courts would apply the strict liability. But we are seeing now from the Constitution, we even have that element of absolute liability that the court is applying. Of course, this doctrine has also been applied in other jurisdictions, like in India. So basically, under strict liability, whereas we are saying that, yes, there is no requirement for there to be a proof of fault on the part of the offender, but under that arrangement, the offending party could actually, in some instances, also rely on certain defenses. For instance, that yes, this substance or the material escaped, but it was beyond my control. Maybe it's on an act of God or something like that. But here, when talking about absolute liability, it doesn't matter. There's no provision for a defense, as it were.
Okay.
Yes.
So when you take into account our urban realities, you have situations where you could have a company that is dealing with hazardous materials. They own a big parcel of land and squatters have moved into that land. Are you then saying that if these people are affected, or if there is sort of like an escape of these hazardous materials from this company onto its land where other people are living, that they would still not be accorded a defense on account of that strict liability doctrine?
Absolute, actually. Absolute.
Absolute.
Liability. Absolute liability doctrine. Because for strict liability, there was escape onto somebody else's land. But here, when talking about absolute, it goes beyond somebody else's land. As long as you're able to demonstrate that there's been the escape and that this escape then has resulted in a harmful effect to the environment, it does not require for you to demonstrate that it went on to somebody else. So it is not confined. I think strict liability, basically, essentially what I'm trying to say is it was a bit confined. But here it is, we are looking at a broader perspective. The question is, did this cause damage to the environment? Not necessarily to the neighbor under a strict liability.
Okay. So a company comes to you, they are a potential polluter in that they are dealing with material which, if it escaped, would cause like tremendous harm or would then be a threat to the environment. What then advice do you have to them in view of the landscape that we are in right now when it comes to environmental protections? How could they mitigate the damages that would probably be awarded against them?
I think the starting point for such companies, because before they even think of investing on the nature of the investment which would have adverse effects to the environment, there's a requirement in law for environmental impact assessment. And based on that environmental impact assessment, if it is done properly, it can actually, to a large extent, mitigate the kind of risks that they are exposed to. Because from the environmental impact assessment, they may now realize that they have to take certain actions, including even in the scenario that you gave. If, for instance, it is a factory that is going to produce certain hazardous materials or maybe some polluting substances or gases, and the effect is going to be almost immediate within that particular environment, sometimes from the impact assessment process, it might even be required perhaps for them to set where they are planning to set, that maybe it might become necessary for some relocation, and of course at their cost, so that later on we don't have a situation where some people within the vicinity come up and say, look, we are being affected by your activities.
Interesting. And could you tell us about a case that the courts, especially the Supreme Court, has decided on these issues and sort of like firmed up the application of these doctrines within our jurisdiction?
Okay, so at least the famous one that we know, and it has gone all the way to the Supreme Court, the famous Uhuru Owino case. I think it sent jitters, especially in the corporate world, when they now affirmed that you can call it business responsibility for human rights, where businesses are being held or corporates are being held responsible for their actions on or their impact on human rights. And as we know, the right to protect the environment is also considered as one of the fundamental human rights that we now have. And this case was interesting. It is widely reported. I think it is one of those cases that confirmed the place of the doctrine of absolute liability in the Kenyan context, at least from a constitutional perspective. And what had happened, basically, it is a case emanating from the coastal region in Mombasa. And there's a company, the metal a refinery company, which was producing batteries. And of course, because of that, when you are manufacturing batteries, there are chemical components that are involved, especially lead. And somehow, some of these hazardous components found themselves in contaminating water, and it had a serious impact. We had things like effects such as miscarriages. We even had deaths, and people were really affected. And the community around that then took up with, of course, the help of certain non-state actors, and they presented the case not only against the company but also against state entities. And what we found very interesting is the court here did not just restrict its awards to the polluter. It went ahead even to hold also state entities that are responsible for licensing and ensuring that the environment is protected. It also made certain findings against them and issued certain edicts against them as well.
So it expanded these protections in saying that we're not just going to apply the statutory polluter pays principle. Even you as a regulator has to be culpable because you ought to have done your job better.
Exactly.
And it's quite interesting because I think one of the parties there was the EPZ authority, and it was trying to mount some statutory defenses, and I mean defenses that are very common in civil litigation, such as we relied on the other party having done its duties, since we don't have a duty to go and investigate whether they've actually done what they've done. They've said that they ought to have done, but the court was like, no, you had an obligation to verify. You have an obligation to perform your duties when it comes to protecting the environment. Yeah, it's quite an interesting case.
Yeah, it is. And in fact, in that particular case, the court even went ahead and it pointed out to the EPZA the fact that even under its own constitutive act, I think they quoted section 23, that they were obligated to ensure, especially where the entity that is within the EPZ is, they have to, and is dealing in hazardous material, that they have to ensure that that material or that substance is contained in some way or form, so that other than the secondary duty of just confirming that the entity in issue here has obtained the necessary approvals and licenses from, like in this case, NEMA, even them at the primary level, they also ought to have ensured that the licensee, in this case, the metal factory company, also adhered to environmental concerns that had been raised.
And we've also seen this attribution of culpability to state entities also being very present in the McQueen petition.
Yes.
Could you tell us a little bit about that?
So the McQueen petition, this is the one for KPC. Yeah, and I know the point you are raising is important because as we know, KPC is a state entity. Of course, it has the mandate to transport or transmit oil. So here there was a discharge of oil, and they didn't, or you can call it oil substances. I'm not sure exactly which one, but it penetrated all the way to affect people kilometers away. And even the fact that that is the point that was being raised by the offending company, that where the harm was being alleged to have reached is not something that they would have otherwise contemplated. But the court was emphatic that the fact that it has been demonstrated that the pollution was caused by the oil substance, then they are culpable.
So foreseeability defenses might not even be applicable in
that
such
particular
situations.
situation.
Yeah, and we also saw NEMA being penalized and being asked to do particular things to remedy the situation. What will be your advice to the regulators when it comes now to protection of the environment, especially when it comes to hazardous material?
I think one of the things that the regulator, NEMA in particular, needs to take seriously is this process of environmental impact assessment. I think we seem to do it as a box-ticking exercise. And because of that, then you realize that sometimes at the time of licensing, we or maybe the concerned parties might not know the extent to which the actions that are being licensed can impact the environment. So it only comes out later on when these such an eventuality should have been contemplated and even mitigation measures put in place. So if we have it as a serious exercise with a serious and truly meaningful public participation exercise, then you'll find that some of these questions can be mitigated or fears can be mitigated at the licensing level. And I think when you look at the message that is being sent out there by the court, especially in the Makueni case and even the Hurowino case, is to try and tell the regulators that, look, your work is not just to dish out licenses. You also need to take your statutory mandate seriously.
The monitoring aspect.
Monitoring aspect, licensing. First of all, there is need for proper, truthful disclosure at the inception. What kind of activity is the licensee or the proposed licensee going to engage in? And therefore, the regulator then needs on their end, because the assumption is that they have the technical expertise that can raise question, foresee even some of these eventualities that can arise.
And that necessarily means that there's need to capacity build and to ensure that you're keeping up with the technology, with the ways in which these things can be mitigated, and also to use the sanctions that you have been empowered under your statute to be able to enforce against these companies.
And I agree with you entirely. Even just to add, when you are saying that aspect of monitoring, I think most of the regulating authorities that we do have is they are concerned more about giving out the license. So at least the pre-licensing. Then after that, everybody seems to go home and forget about the licensing aspect. I mean, the monitoring aspect, where you're supposed also to follow up when we license this activity. How is the operation? How are the operations going on? Are there any concerns in view of these activities? And is there a need to have some mitigating measures put in place? So it's supposed to be a continuous process rather than the scenario that we have, which in most cases we hear about environmental issues and compliance at the pre-inception stage. After the plant or the company is up and running, then we forget about it.
Yes, and now maybe the other involvement will be when someone is complaining about something that has gone amiss.
And even then, sometimes people complain, but unless it leads to public, concern or interest, or it sort of acquires public interest, then you find sometimes they are not even picked up.
Okay, so what then are the policy implications when now it comes to the policymakers and the legislators? How do you empower these regulators to actually be able to do their job?
Some issues are not even about legal empowerment, as it were. I think we have, as at this point, we have fairly good laws to protect the environment. The problem that I think I foresee here is the problem of capacity, the way you are talking about, the problem of financing, because for you to keep monitoring, then you need these experts to also be facilitated to move around, and that they are able to then take action. Because you can have a good law, but if it is not executed, if it is not enforced the way you have said, then it is just as good as the paper on which it is written. So we have that disconnect between what the law requires and actually what is done. Some of these issues that we are talking about, you can also empathize with some of these organizations because they are formed, yes, they are given the powers, yes, but so often you hear about the capacity, the resources.
Yeah, and now it appears that there's even need for the companies, the regulators, and government itself to take seriously the environmental, social, and governance aspects and factors in running their day-to-day activities. What kind of advice would you give to now someone seeking to enforce this right, who has suffered harm and wants to get proper compensation from the courts? Yeah.
So I think a starting point, the way we had said, it is now easier to access court to enforce either threatened or actual breach of the right to a clean environment.
So you don't have to wait for the harm to happen?
You don't need to wait. You don't also need to be affected, as it were. You can approach court through the constitutional route. But of course, if you are seeking for compensation, then you also have to take some more step that just other than just saying that there's that threat in itself. If you look at even the Uhuru Owino case, there's so much that went into it. Experts who had been retained to be able to give their evidence in that particular case, because some of the issues to do with whether or not there's been injury to the environment, as it were, is sometimes requires some scientific evidence. With just the plain eyes, it might not be easy for you to make out your case, and sometimes even demonstrating that certain levels of like gas or certain chemicals are hazardous or they are beyond what is required, you might need to have some scientific evidence to do that. Yeah, so the point I'm making is it is easy to access court because, as I had initially indicated, you don't even need to demonstrate that you have suffered or somebody else has suffered a particular loss or damage which is quantified or otherwise. So long as there is that threat, you don't need to go that extra length of demonstrating. But if you are seeking for compensation, remember that courts don't act in vacuum. You must have some basis for saying, give me 1 million or give me 2 million. Of course, the courts will fashion a proper compensation, if you're looking at compensation, based on the evidence that you present. So that is why you can find one award is for 1 billion or 1.3 in the case of Uhuru, or another one is 10 million. It will depend. What is also the scale of the effect that has been caused? Yeah.
Okay. And for a young and upcoming advocate who wants now to sharpen their skills in this area of environmental law protection, what would your advice be to them? What toolkit do they need? What resources can you recommend?
I think this is one of the areas that we are saying, I don't know that we should still call it emerging, but it's a very interesting area. Of course, it is always pays to be properly grounded in the law itself. Environmental law is somewhat a specialized area that you need to understand the principles that apply, things like polluter pays principle, to be able to know some of the doctrines that we have alluded to, and the fact that there's been a shift from the common law approach to the constitutional approach that we have. And of course, also as a lawyer, since, as you have said, using the example of maybe just what you can call a citizen walking into your office or your chamber and saying that, yeah, they have this claim, and the fact that we have said it is not necessary that they have to demonstrate that they have suffered personally. Maybe somebody who wants to do or to take up the claim on behalf of others, you should be able to appreciate. And of course, that is where now the skills come in for you to appreciate that you can actually do this on behalf of others. So it would help if you're able to get some skills or gain some skills in environmental law, maybe even do some specialized courses around that, because we even have international instruments that govern this. Since we started talking about or having conversations around climate change and environmental protection, the international community has taken it seriously from the Paris Agreement. We now have several protocols, the Kyoto Protocol, the Rio Declaration, and so on. So you need to be properly grounded. And you can see that even in the Supreme Court decisions around this area, they are also relying on these international instruments to ensure that even where maybe locally we have a lacuna, then these international instruments can actually form the basis for the justification to intervene in a particular case or even award certain remedies in those specific cases or circumstances if they so warrant.
Okay. Thank you very much for sharing your insights with us. That brings us to the end of this episode. We thank you for joining us.
Thank you very much. This is a very interesting topic, and we hope to have more conversations around it, especially on environmental litigation.
Yes.
Now and in the future.
Okay. Thank you.
Protect the environment.